It is commonly and mistakenly believed that only the original publisher of a libel is at risk of being sued for defamation, and that repeating what has been published elsewhere is a defence, or is safer than being the original publisher. Unfortunately, that is not the case. Every publication is treated as a separate libel, and a claimant can decide to sue the person who repeats the defamatory allegation, as well as, or instead of, the original publisher. This means that similar care is required when repeating defamatory allegations or republishing information as when you are the original publisher. It's very common, of course, for campaigning organisations to refer to and rely on information published by others in their own publications, for example, articles by journalists, reports by other organisations, or academic studies. This is both necessary and unavoidable. However, it is important to try to rely on reliable sources of information if you intend to repeat a defamatory allegation. In most cases, a publisher will intend to publish a report in a particular country. However, when a report is posted online, publication can occur simultaneously in many parts of the world. In English law, material is published online when it is accessed or downloaded in England and Wales. This means that material posted in another part of the world is published here when someone clicks on and reads the URL address while in England. A claimant can therefore bring a claim in England against a foreign publisher. But if the publisher is outside the UK and EU, for example, a US newspaper or a Canadian blog post, the claimant would have to show that the UK is the most appropriate place to bring the claim. We will come back to this point later in this module. The serious harm requirement was introduced by the Defamation Act 2013, and its purpose was to make it harder for individuals and companies to sue for libel. Now it is no longer sufficient to show that a statement is likely to cause some harm to reputation. A claimant must show that the statement has caused or is likely to cause serious harm to reputation. This makes it less likely that a defendant will be sued for trivial allegations, or where publication has been on a very small scale, or where the person concerned already has a bad reputation. Where the defamatory allegation is very serious, such as an allegation of criminality or serious wrongdoing, the court may infer the likelihood of serious harm without requiring evidence. But in the case of less serious allegations, the court may expect the claimant to produce evidence of actual harm. In addition, in the case of companies, they must show that the defamatory statement has caused or is likely to cause serious financial loss. Often, this will be hard for companies to establish. Organisations who seek to criticise the conduct of companies now have greater protection from defamation than they did previously.